Alrighty then, we'll go ahead and get started. My name's Tyson Benson, here from Advent LLP. We're going to talk about when is software patentable. It's kind of an important question on a lot of software developers' minds. Get a question asked quite a bit. A little bit about myself. As I mentioned, I'm a patent attorney at Advent LLP. My background's in computer engineering. Graduated from Iowa State with a computer engineering degree in May of 2004. Transitioned to Creighton, transitioned to Omaha, went to Creighton from 06 to 09, and have been in Omaha ever since. And so without further ado, and if you have questions, during the presentation, please raise your hand. I kind of want this more to be a discussion rather than a presentation, so that if you have questions, let's get them out and then we can go from there. So without further ado, the roadmap. We're going to talk about what is a patent. We covered this in a previous presentation, but I think it's important to cover, especially with regards to what we're discussing and kind of get the landscape of where we're going with regards to what patentable subject matter is. We're going to talk about requirements to obtain a patent, and then software patent issues, kind of the crux of what this presentation is. Here's a map. This is took this from a patent application filed by Apple. You'll recognize the iPhone outline, and these are usually what you'll see in any patent application: drawings, written description, and so forth. So, what is a patent? It's a set of exclusive rights that allows one to exclude others from making, using, or selling within that country that they obtain patent rights. So one can obtain a patent within the United States to prevent someone from selling, using, making, and basically utilizing the product or process described within the claimed subject matter or claimed invention at the end of the patent application. We'll kind of discuss that here in a little bit. So one could think of it as monopoly rights that are granted by the government to someone for patentable subject matter. They can be utilized, commercially utilized in two basic ways: directly or indirectly. Directly, you can make and you build a business around it, or you could license it indirectly to someone, or just sit on those patent rights. You don't necessarily have to utilize those patent rights or go out and enforce them. You can sit on them. You can kind of think of it as a deed to property. If you want to sit on your property and not do anything or build up on your property, that's perfectly fine. The government doesn't tell you have to do that. However, patents and patent applications do lend business credibility to businesses and showing that they're trying to protect their inventions. Under what conditions are patents granted? Well, the government tells us that they have to be new or novel, they have to be useful, non-obvious, and a written description that fully and concisely describes what their invention is. So you can kind of think of it as an engineering manual, or in software describes the modularity, the interfacing, how all the components of your software interact with each other, and what's the functionality that's performed. First and foremost, the statutory requirements. Whoever invents or discovers any new useful process, machine, or manufacture may obtain a patent therefor. This is set forth in 35 U.S.C., it's a statute, 101, that describes the requirements to obtain a patent. How is it obtained? Well, client comes to me, or inventor comes to me and says, I want to obtain a patent. We get down, maybe provide some flow diagrams, describe the functionality to me. We then set forth in drafting a patent application. We send that patent application to the government or to the U.S. Patent and Trademark Office. They will eventually examine it. A patent attorney or a patent examiner will pick these applications up, and then they review it as of the filing date. They look backwards and see if it's truly novel or non-obvious. So what they do is they go through other patent applications, technical journals, IEEE articles, to see if it's been described before or if there's something novel about it. If it is novel, they'll issue you a patent. You'll pay an issue fee. Be mindful that the filing of the application does not create the enforceable rights. It allows you to put patent pending, but it doesn't give you the monopoly rights as of yet. And then you'll have to maintain your patent with maintenance fees every couple of years that the government sets forth. Novelty and non-obviousness. Claims must describe an invention that is novel and non-obvious. So at the end of your patent application, we're going to describe or write down some claims that you're asserting is what your invention is. And I have some sample claims here in the back so you'll kind of understand a little bit better. But the analogy I utilized before was it basically is a or it describes your property line. What's out there, what's new, what are you saying is new to the patent office? Invention is not patentable if the claim subject matter was previously disclosed in the journal. It also is obvious, or has to be non-obvious. An obviousness rejection from the patent office, an invention is not patentable if obvious to someone with skill in the art. So if they can't quite get it in one document, say an IEEE journal, they might look at two IEEE journals and say, well, if someone, a software programmer, was reading these journals together before the time of the application filing, would these been obvious to combine these two to create the invention or the patentable subject matter? If the examiner asserts that it is, then they'll reject you under obviousness. One of the most important things that courts are struggling with right now, or the concepts, is whether or not a software, the functionality that are described, is an abstract idea. And we've seen this, or patent attorneys, as in we, have long seen this struggle in many cases. The court hasn't articulated a good test for determining whether or not something's abstract or whether something is a patentable invention. And here are some of the recent cases. Bilski is kind of the preeminent software. Is it an abstract idea or software? That's a Supreme Court case. The CLS Bank and the Bancorp services. As you'll see, the Federal Circuit is a federal court that basically just deals with the patentable subject matter. And so they hear cases to determine whether or not something is patentable. And then it goes down, and why is the Federal Circuit important? Well, this law then goes down to the patent examiners, and the patent examiners will pick up and determine whether or not something is novel or non-obvious, or if it's an abstract idea. And it's out of Washington, D.C. The important thing to note about these two Federal Circuit cases, the CLS Bank, Bancorp, is that the Federal Circuit initially, when they receive a case from the federal court in Nebraska or Iowa, they sit in 3-panel judges. They can then, if there's conflict between varying panels, because there's 12 judges, so there's obviously multiple panels of 3 judges that'll sit and go over these cases. If there's truly a split or a philosophical difference in this, they will then sit together, what's called en banc, but they'll sit together as 12 active judges and then try and get through this philosophical difference and lay down what the law is. And what we'll see here is that CLS Bank came out one way, Bancorp came out the other way, and at the end of it, we'll hopefully be able to tell you what you need to do if you're trying to obtain software patentability. Apologize about the legalese, but it's just kind of the abstract idea that we're trying to go through and really give you a good idea of what to expect, because in some respect, patent attorneys don't know what to expect. They recently, the CLS Bank was reheard, and the test, the 2 questions that the court asked was, what should the court adopt to determine whether a computer-implemented invention is an abstract idea, and when does a computer in a claim lend patent eligibility, and should the type of claim matter in assessing patent eligibility? In one of these, MySpace versus Graphon, software is like a fine wine. This is an interesting. the effort to descriptively put this 101 jurisprudence, determining whether or not it's an abstract idea, is like describing a fine wine. It could be earthy, fruity, nutty, tart, woody, whatever. But we haven't really articulated a reasoning for getting this abstract idea and determining whether it's patentable subject matter. Another way of describing it is this is a murky morass. But as I mentioned before, efforts are underway to create a test to articulate what is patentable subject matter, so that as software developers you can kind of know what to expect when you're going to a patent attorney, or if you're doing your patent applications yourself. Is it more of an abstract idea or algorithm? If so, then the patent examiner is going to reject you and say, you don't have rights to algorithms, because algorithms in a way it's E equals MC squared, or it's a natural law. So if you didn't create the algorithm, you're just utilizing the algorithm, therefore you do not have exclusive rights or monopoly rights on that algorithm that's naturally been there. You have to actually create something. And so the key is to figure out what language to utilize when going to the patent office and utilizing a patent examiner, and that's why we're trying to figure out what this test is. As one court case said, an abstract idea, it's a fundamental truth, an original cause, a motive. It's not entitled to exclusive rights under the Patent Act, because a patent would wholly preempt anyone else from utilizing that algorithm, that formula. If Einstein was able to receive a patent on E equals MC squared, well then no one would be able to use it unless Einstein or the owner of that patent would have allowed, E equal MC squared to be out there. So there are many different types of claims that you can utilize. First one is a process. You're claiming the invention as a method. So a method of doing something. What is the functionality? So what, from the processor's standpoint or viewpoint, what's happening? What is the processor doing? Machine, it could be a data processing machine, so you're claiming the processor, the memory that holds the computer code, and the computer code instructs the processor to carry out some specified functions. Or you can do it from the computer readable storage medium that includes the computer code. And these are all, if you go to a patent attorney, we'll be happy to kind of go into this a little more. But we're going to now get into what exactly the claims are. So the Bilski. What was the technology directed to in Bilski? It was directed to a method of providing fixed bill energy contract consumers. And this was the claims distilled down. And it's important to look, where does it say in here about a computer or a processor or what the actor is? It's not. There's no computer, there's no processor. So when a court looked at this, when the Supreme Court, when the Federal Circuit, when the patent examiner looked at this, they said, well, initiating a series of sales or option transactions between a broker, purchaser, users. We're then identifying producers, sellers of the commodity. And then we're initiating a series of sales or options or transactions. Well, that reads on something that potentially I could do, you could do. It doesn't say anywhere that there's a computer in there. So this, when the court's looking at this, they're saying, man, this is an abstract idea. This has been out there before, and therefore it's not entitled to patent eligibility because it's not a process, it's not a machine, it's not, it's just a set of abstract ideas that have been previously out there, or maybe not out there, but they are abstract in the sense that we don't really know who's doing the initiating, the identifying, and the initiating again. Bilski came down, patent eligible subject matter. What they did state, though, was that a machine or transformation test could be utilized as an important clue. So is this process that we just talked about, was it implemented with a particular machine, or is it transformed from one thing to another? So courts and patent examiners, if you submit a patent application, one thing I've seen patent examiners do is kind of say this, assert this test as machine or transformation. Is it useful? or is it implemented with a particular machine? If it's not, then more than likely than not, they're going to say, no, you're going to have to prove that it's with a particular machine or it transforms an article. So now, after Bilski, we got the philosophical divide. As I mentioned, two different panels comprising of 3 different judges within a month of each other came down with 2 contradictory decisions with regards to patent eligible subject matter. And this really shows the philosophical division, and this is what they're trying to reconcile with this new CLS Bank rehearing, is that they get all these judges together and figure out what exactly is patentable subject matter with regards to software. CLS Bank, the software is patent eligible. Bancorp, the software is not patent eligible. CLS Bank, here was the claims that we're talking about. So it's directed to a system that maintains a shadow credit and debit records with an independent third party. So it's in what this is trying to protect is making sure that each party is making its obligations, and if it doesn't, then the business transaction won't go through. So as you see here, it's talking about creating a shadow credit record and a shadow debit record, obtaining an exchange institution start of day balance for every transaction, resulting in that it adjusts each respective party's shadow credit record or shadow debit record, and then it goes to this final step. As I mentioned before, those 3 judges on the Federal Circuit found that it's patent eligible subject matter because they said that this qualifying characteristic of abstractness must exhibit itself manifestly to override broad statutory categories of patent eligible subject matter. They just looked at this and said that this, by just looking at it at an abstract, or I shouldn't say that, that's probably a bad word with where we're going, but they looked at it and they said that this, the characteristics of these claims, what's claimed here, disqualify it from the abstractness, and it must exhibit itself manifestly in order to override. So they're basically saying it must be so clear to them that it is abstract, it would override the broad statutory categories. So basically, we have the judges here that are very broad. They're letting pretty much anything through. They're the gateway judges that say, all right, pretty much anything's patentable subject matter. We're going to let it go through and let the patent examiners decide if it's novel or non-obviousness. We're going to let this go through. We had the judges on the other side in Bancorp. They held that the method for administering and tracking value of life insurance policies was not patent eligible because explicitly, as I mentioned before, the independent claims at issue did not require a computer. As it kind of says, a computer must be integral to the claimed invention, facilitating the process in a way that a person making calculations or computations could not. Here's the claims or the elements set forth in Bancorp. What they said, there's no computer. A person could basically do this. Abstract idea, you are not entitled to a patent if there is an abstract idea, because basically a person could generate life insurance policy, calculate, determine, and so what may have saved the day could have been that it included a computer or a processor, or if the processor is the one performing these steps. Now, what does this mean? As I mentioned, CLS Bank was recently reheard. They put aside the decision. Full circuit or full slate of judges heard CLS looking at the questions that we talked about earlier of whether it depends on the claims or what test actually needs to be articulated. And like I said, this is an opportunity to articulate a bright line rule so that software developers have an understanding of what needs to be going through. Now, what does this mean for you? Well, if you're doing your own application or you're going to a patent attorney to have them present you a patent application, make sure to present different types of claims to the patent office. Maybe one that's set directed towards a process, one that's set to a machine, or ones that's set to the manufacturer, the storage medium having the computer code, make sure to include one or more flow diagrams that illustrate the functionality of the invention. Make sure you include detailed block diagrams illustrating how each component interfaces. So how does the transmitter or the transceiver communicate with one another, or what does the what do the flow diagrams show the software performing? What functionality is actually performed? Bottom line, include which actors are performing what functions. Maybe identify something that's happening on the server side. So if your server is performing all of these functions, make sure to limit your claims to what the server does. And then you can have another claim that maybe goes to what the client does, or so what my what is happening on my iPhone device, what functions is it performing in relation to the server, and make sure that they're separate claims directed towards that. Otherwise, you might just be well suited in order to get on the server to has many claims as you can directed towards different areas of technology. And so one, as I mentioned, server, the other client, machine, system, whatever. Patent examiners do not like claims directed to the concept alone. When I talk about the concept, they don't like seeing that it's just a bunch of steps that could be performed by a human. What they're going to say is, no, this is a broad concept. You're trying to patent the concept that would be out there already. Therefore, you're not entitled to it. If you maybe throw in a processor, by way of a processor, then you can get to patent eligible subject matter, but then they'll have to look at anticipation or novelty, non-obviousness, and abstract idea or an algorithm. They'll say that an algorithm is a naturally occurring event, or it's already been out there, and therefore the concept alone is not entitled to patent eligibility. Here are claims that I've actually written, and it's in a patent application that is published. So you can find it, my website that I have listed at the back of this presentation. I have a couple samples, but they're freely available, freepatentsonline.com or google.com/patents. So a mobile electronic device includes a display, an input device, a memory to store one or more modules being the software code, processing system to execute, and then cause route selection information to be displayed on the display, receive a selection via the input device, and so forth. Here is the matching method claim that I talk about, it causing a map to be displayed on the map. So we have something concrete there. We have the display device, and we can also include maybe a processor if the examiner wants, but basically this is kind of this without the display, or maybe without this last step, could potentially be said, oh, this is simply a concept. It's not directed towards, or it's not limited to a specific computer or processor. So what you see here is claims directed to both the mobile electronic device or the machine method, and then we could also maybe do another claim towards the manufacturer that stores the computer code. Here are some flowchart examples. This is a flowchart directed towards the previous claim. So we determine one or more routes, display route selection information, receive a selection. So this is all from the perspective of the server in a way, or actually from the device that interfaces with the server, because on the device itself it determines the routes, displays the routes, receives a selection from the person, and then it displays the map of the selected route on the displayed device. Here's another one. I took this from an Amazon, recently published Amazon. So we receive a request for authentication, send a request for a set of parameters, receive the set of parameters. Is the client in compliance? So as you can see, this is from the server aspect. This is purely the functionality that's being performed on the server. This is the code from the server point of view, or the program from the server point of view. You could then maybe have a flow chart from the client perspective, sending the receive authentication, and then receiving either the error message or receiving the authentication seed to the client or at the client. Here's a block diagram. This goes back to what the application that I drafted, and it's publicly available. We have the mobile electronic device, interfaces with satellites, cellular provider, internet provider. It has the processor, it has navigation module, it has memory, it has map data, and then a little mobile device right there, kind of showing the display device. But this is kind of what you're looking for if you're looking at trying to obtain patent eligible claim or subject matter when it's with regards to software, is that you need to make sure to be thinking about all of these different questions of where the functionality is occurring, making sure that the functionality is described as the processor being the actor, or the client being the actor, or the client device or the server being the actor. If you're just trying to go broad concepts with broad strokes of the brush, you're more than likely going to be rejected by the patent office as being directed towards patent ineligible subject matter. And so with that, is there any questions? It was kind of a legalese presentation there, but in order to fully understand patent eligible subject matter, it's something that kind of had gone through. So, please.
Does patent eligibility depend on who the examiner is?
A lot. Yes.
Pretty consistent?
No. As with the Federal Circuit panel of judges, patent examiners are their own, they have their own set of standards that they're governed by. However, each one has their own different interpretation because they don't have a clearly articulated model or a test to determine whether or not. So, for instance, I've seen some patent applications that I've drafted that are pretty close to one another, not the same invention, but the same structure of claims that I'll see one patent examiner reject it as being rejected towards the concept, another one that says, yeah, go ahead. And I don't want to say it's a crapshoot, but sometimes it really is, because it depends on the patent examiner and whether or not, you'll see. And there's actually a program out there that some other patent attorneys have developed where it provides statistics on each single patent examiner of what kind of rejection that they usually provide, and whether or not you actually do obtain a patent from them, or what the allowance rate is, or how much negotiation you have to go through, because every time you negotiate, there's rounds of negotiation with the patent office, and sometimes it's one round of negotiation, sometimes it could be 3, 4, 5. Some of these Apple patents that you see, they keep on submitting the government fee to enter another round of negotiation because the patent examiner is just rejecting them, or they're trying to get around different prior art. So it does depend on there's not some uniform requirement that the patent examiners abide by.
That's just luck of the draw then?
Yes. Yeah, it's you don't. Yeah, they pick. So when you submit the application into the queue, it gets divvied out into group or art units. So there's agricultural art units, there's computer art units, there's chemical, pharmaceutical, all these different little art units within the patent office. Within those group units or art units, there are then individual patent examiners based upon what their background is. If for me, like computer engineering, I'd go into computer or electrical. If it has an agricultural background, I'd go there. And so once you submit the application, there's a pre-exam. People look through it at the patent office. They say, okay, this is the group art unit. And then it's just basically queued out to whoever, I would assume it's evenly, because, they may have 10 patent examiners within a group art unit or art unit, and they'll just say, you get this one today, you get the next one, you get the next one, and it's just a round robin, or they just get it to whoever it is. So yeah, you never know, or you can't choose as an applicant who the patent examiner is going to be. Sometimes people try and wait them out by filing the negotiations and stuff, because sometimes they'll leave and go into private practice or go elsewhere, and so you hope that if they leave, then maybe you'll get a lucky draw, and maybe sometimes you don't. There was someone over here. Yes?
What's the average time from first applying for the patent to actually being approved? I'm sure it depends on what you're applying for, but what's the average time?
It's actually sped up very quickly. It's amazing. Like, first, I'll answer it, give you a little different answer then, and then get back to what you just asked. But used to be that there was quite the backlog, maybe 2 to 3 years before you actually get a first examination. That's before someone actually, the queue is so long with all these patent examiners that you're not getting your application initially examined until 2 or 3 years since you originally submitted it. Now that's a long time in technology terms. Now I've seen under a year, 6 to 8 months. They've made a concerted effort to try and get patent examiners to examine applications at a quicker rate. So we're starting to see that turnaround. Now, typically with the negotiations, this is average, so depending on the technology, but just usually it takes maybe 2 to 3 negotiation rounds. Each negotiation round could be 2 to 3 months before you hear something back, so you submit something, another 2 months. I would say anywhere from maybe 2 to 4 years at this current rate before you'd actually get something issued if you have patent eligible subject matter. So once you file, 2 to 4 years, I would say on average.
Okay. And then what's the average cost as well?
Average cost, that's a good question. It can be expensive sometimes. And typically what I tell people, this is, again, on average, so depending on what the technology is, it could be anywhere from initial filing fees, including filing fees. If you're coming to a patent attorney, it could be anywhere from $2,000 to $10,000, anywhere from that. So kind of have to make that, and I always tell people it's a cost-benefit analysis. But if it's truly something you're trying to protect and obtain exclusive rights on, it's probably important subject matter to try and protect and exclude others from making, using, or selling.
Where do you raise the courthouse rule or raise the file rule?
There is. Doing your homework on the American Invents Act. Recently, or on March 16th of 2013, the patent office or the patent laws changed substantially. So now it was previously first to invent. So it didn't matter who got to the patent office first, as long as you had evidence to show that, hey, I actually invented this first and I have evidence of this. So, if your competition or someone invented the same exact thing, but they conceptualized it after you and reduced it to practice and filed and ended up filing before you filed afterwards, but you had earlier conception and trying to reduce it to practice, you would have evidence to show that you were entitled to that. Substantial change is it's first inventor to file now. So it all depends upon what your filing date is. If you have in that same situation, the opposition would be entitled to the patent because they filed first, even though you actually conceptualized it first and reduced it to practice. Doesn't matter if it's if you get to the patent office first and you filed, then you're entitled to the patent for them. And that's more to harmonize that with the rest of the world, because the rest of the world also has the same rules of first inventor to file. Yes?
What's your take in regards of open data?
Open source data? Oh, open source? Technology? Open source technology is definitely, they would be against patents to some respect, or GPL or the GPL licensing. They take a hard stance against it. The one thing to know about open source is you have to be aware of what the agreement states. Like these copyleft agreements is what they're called. They say that you have to, once you accept it and you make any distribution of your product, you have to change all the improvements of your code, or any code improvement. You have to actually publicly make that source code available as well. And so, it's good if it's free. You don't have to reinvent the wheel. It's not proprietary. But if there's something that you've obtained with these copyleft licensing, you then distribute some type of product, you'll then be subject to that licensing agreement where you'll have to make your improvements available as well. Otherwise, there's been instances where they'll come back and try and take you to court and saying all of this. As a computer engineer, our C++ programming was all open source, so it all depends on what. It certainly helps out on the bottom line in that you don't have to reinvent the wheel or obtain proprietary software. But then if it's truly proprietary software that you're trying to protect on the back end, well, then you might be having to distribute it in open source. So there's the pluses and minuses of it. And certainly copyleft licenses, they don't want to try and obtain patents. And I believe the GPL v3 has some explicit language in there that says you have like a licensing agreement of some sort, so that if you do obtain patent protection on your functionality, you agree to provide some type of license, agreeing that you won't sue it or that they have the right under that to practice it. So.
Another question. So, what would be your recommendation for a strategy if I'm developing software? Would I be better off as a trade secret and then getting the patent, or should I get the patent and then what would be your?
This is all hypothetical, so I don't like to comment on any specific circumstances. But hypothetically speaking, someone came to me and asked me, the trade secrets or a patent. It really all depends, because trade secret, one can reverse engineer. If someone reverse engineers your technology, and then it would be open to the world. Patent rights, you're publicly making them available to everyone to see through your patent application. You're describing the functionality that you're trying to obtain, but you're also potentially going to be able to reserve a monopoly from the government that preserves 20 years from the filing date, gives you exclusive rights to sell, make, use, or utilize whatever your subject matter is in the patent application. So it's all depending upon what technology it is. If it's a trade secret, hopefully it's not easily subject to reverse engineering. Otherwise, if someone does reverse engineer that product, then you potentially would lose out to it, and you wouldn't be protected by trade secrets anymore. So it's kind of a balancing what's best for your company, or the hypothetical company in this case. So.
Do you have any basic rules of thumb? Let's say if you're a startup company, or you're a computer engineer or something, you come up with a software program, you don't know if it's patentable or not. I mean, do you have any basic rules of thumb of where, okay, this maybe could be patentable, this is not going to be patentable, or maybe some examples, like if your software is closer to this well-known software, it's worth a shot. If it's more like this, not worth the time doing a patent, you should try to protect it somewhere else.
It's all about, a very important aspect of that is the drafting. How you draft, how the draftsperson drafts, how the functionality works. Because, like I said, it has to be novel or non-obvious. And so if you're aware of some prior art or of what the software functionality occurs, but you make some improvement, because everything asserted in the patent application, or there's some type of improvement therein. And so what you're trying to do is you have some new improvement that you're trying to accomplish. And so one thing I do, or sometimes people ask me if they're wanting to do some poking around, there's freepatentsonline.com or google.com/patents that does a pretty good job. I don't put in exactly what the invention is, or you'd never put it in exactly what your invention is, but you maybe see, like, type in some functionality at a broad level and say, if my computer program accomplishes this, maybe at a broad level, type in what the broad concept is, and kind of do see what the landscape of the patent applications out there that cover this, and then kind of take a look through. But there's no really set rule, if it's closer to this and not that. It really is what I ask people: tell me what the improvement is. What is the engineering improvement here? What's this product accomplish better as compared to this? Is it greater processing time? Is it what functionality does this perform that you've never seen before? And that's kind of my answer to that, or that's the answer to that question. But if you want to know or kind of have a landscape view, go to Free Patents Online or google.com/patents, and at a very broad level, just type in and kind of see what's out there and see what pops up, and you'll kind of get a better idea of the prior art is out there, or if it is anticipated or non-obvious or obvious. So